Hello, this is Joe Gailey, and I want to welcome you to another one of our educational webcasts on the subject, Employees in Your Business, Your Obligation to the Employees. Today's topic is going to be concerning the EEOC, that is the Equal Employment Opportunity Commission, and what is their role in employment actions, and why should that make a difference to you as a private employer? Well, that role is immense. Before an employee can sue an employer for some things like Title VII claims, Americans with Disability Act claims, FMLA claims, or retaliation under any of those acts, they have to first file a complaint or what's known as a charge with the EEOC. And they have a certain specified time to do that. Usually it's 180 days from the date of the last possible incident of discrimination, but it can be extended for a longer period of time under some circumstances. Now, the purpose of their filing the claim is not to weed out frivolous claims. The purpose of their filing a charge with the EEOC is to give the EEOC the opportunity to file suit on their behalf against the employer. Now, let me repeat that because that's very important. The purpose of filing a charge with the EEOC is to give the EEOC the opportunity to file suit against the employer. This is a government agency that could well be filing suit against you, and I don't have to tell you how expensive that would be to defend. Now, when the employee makes the charge, then it works its way into their system, and eventually the employer is notified of the charge and is given a amount of time to respond. Today, that's all done over the computer. You file your charges electronically, and the employee has to file their responses electronically. They do have a very effective mediation program at the EEOC, and I would encourage anybody who faces an EEOC claim to ask to go to mediation. It's free. They pay for all the mediation costs, and it many times results in settling the case at a cost far more reasonable to an employer than it would be going to a trial. Now, if you don't settle the case at mediation with the EEOC, then they are going to ask you to provide all sorts of documents and information, a survey of your workforce, say over the last 5 years, separated as to sex, separated as to race. They're going to want to see the pay scale of all your employees, classified by race and sex, to see if there's any obvious discrimination in pay going on. This is going to be a huge burden on your business, just the paperwork burden of meeting these things. And it's going to take some time. Usually, it's not unusual for an EEOC charge to take 2 years to come to fruition. If the EEOC, after investigating the claim, if they decide not to pursue it, then they will give the plaintiff what's known as a right to sue letter. And then the plaintiff can sue the employer. That is, the disgruntled employee can then sue the employer in district court with a private right of action. But it has to go to the EEOC first before they can do anything. I want to thank you for tuning in to this installment, and I want to ask you to please tune into the others and try to get a better education on what your business is responsible to do and how your business can avoid problems in the future. Have a good day.